Please proceed.
Mr. Chair and members, thank you for the opportunity to present Assembly Bill 1937. I will be accepting the committee's amendments listed in the analysis and will continue to work with stakeholders to improve the bill, including removing the phrase adjacent to. I'm also proud to add the chair of Natural Resources as a joint author. AB 1937 underscores and strengthens a concept in existing law called the loading order and protects California's communities that are the most cumulative impacted by multiple pollution burdens. It requires the utilities to take all feasible efforts to meet demand through all available renewable energy, energy storage, energy efficiency, and demand reduction resources that are cost-effective, reliable, and feasible before approving contracts for any new gas-fired generation. Once the utilities have demonstrated these efforts, and if the need for new gas generation still exists, AB 1937 requires the utilities to prioritize bids that do not disproportionately impact communities that already suffer from multiple pollution burdens and environmental impacts. Members, Assembly Bill 1937 is a step forward in California's transition to clean energy and seeks to ensure that our most vulnerable communities are not left behind. I ask for an aye vote. Go ahead.
Thank you. Thank you. It's late in the day. Thanks for the time. Good afternoon, members of the committee. My name is Shauna Lazaro with Communities for a Better Environment. We're a member organization of the California Environmental Justice Alliance, representing over 20,000 community members throughout the state. We're here in strong support of AB 1937. How California meets our energy needs, how we procure energy, is in the midst of a paradigm shift. AB 1937 is an important clarification of what the utilities must take into account when seeking and contracting for generation, both renewable and gas-fired, so that we do not invest in a polluting, unjust energy system despite ourselves. First, the law already says that when procuring new generation, utilities must follow the loading order, yet we're not seeing procurement plans, requests for offers, or contracts that reflect the loading order. This bill codifies a loading order evaluation as a backstop in case every other procurement moment has failed to seek preferred resources rather than gas-fired generation. Second, the law already says that when contracting for renewables to meet the renewable portfolio standard, the utilities must give preference to projects that benefit disadvantaged communities, but the Public Utilities Commission thinks that that only applies in a narrow RPS-only context. This bill clarifies existing law by removing this loophole that the legislature never intended. Finally, the PUC's decisions and procurement guidance handbook already say that when new gas-fired generation is needed, utilities should give greater weight to offers for new gas-fired generation, not in communities already overburdened by pollution. But the PUC is not even asking the utilities to gather information about the communities in which proposed plants would be located. This bill clarifies that the rules exist, they apply now, and they will apply in the world of SB 350's integrated resource planning. This is not a sea change, but it is a vital correction of a vital regulator to realize the protections the law promises to the state's most vulnerable communities.
Please proceed.
Thank you. My name is Lauren Navarro. I'm here from Environmental Defense Fund. Thank you and good afternoon. AB 1937 is a simple bill with a simple but important intent to reduce the amount of new fossil fuel generation going into California communities already burdened by significant levels of air pollution. With the committee's amendments, 1937 would require, first, that utilities demonstrate compliance with the state's loading order, a long-standing state preference for clean energy resources in electricity procurement, before pursuing fossil fuel generation. Second, if the utilities must pursue fossil fuel generation, that they consider the burdens already being faced by highly polluted communities in examining their options. And third, it broadens an existing renewable portfolio standard requirement directing clean, renewable resources to high poverty and high pollution communities. The PUC already implements the state's loading order. This committee's amendments simply clarify that process. And the PUC is already responsible for implementing the state's most important environmental policies for the electricity sector: SB 350's 50% RPS and greenhouse gas reduction mandates. Impacts to our most vulnerable communities are just as critical and should be considered by the PUC. In all, this bill would help ensure that California's highly polluted communities see more clean air and more clean energy while moving the state forward in its goals to build a cleaner, healthier electricity system. For these reasons, we respectfully request your aye vote. Thank you.
Other witnesses in support?
Bill McGavin with the Coalition for Clean Air in support.
Kelly Doe on behalf of California League Conservation Voters in support.
Marcela Gutierrez Graudinch with Azul in support.
Juan Altamirano, Audubon, California in support.
Amy Vanderwalker on behalf of the Asian Pacific Environmental Network in support.
Andrea York on behalf of the Clean Power Campaign in support.
Quentin Foster, also on behalf of California Environmental Justice Alliance, in support.
Witnesses in opposition?
Thank you, Mr. Chairman, members of the committee. I'm Jan Smutney-Jones, and I'm very reluctantly in opposition to this, but we continue to oppose this bill. We will look at the language. We've been working with Mr. Gomez and Mr. Gomez's staff, and we will see if this works. But for now, let me just be sure you fully understand why we are opposed to this bill, because we don't do this lightly. We recognize the fact that there are legitimate environmental justice issues in this state. We're not disputing that. We are not disputing the fact that there may be power plants in low-income neighborhoods, but there also are power plants in upper-income neighborhoods like Carlsbad, Huntington Beach, Alamitos, places that one does not associate directly with having adverse effects on discriminating against people in those neighborhoods. So we want to be clear that there is a process that undergoes right now where the procurement process that's done by the PUC takes into consideration energy efficiency, demand response, a whole litany of things with respect to so-called preferred resources. Those are put in plans that the utilities bring forward, and then they have an auction, and they select from those resources. Now, I realize that some people complain about some specific auctions. I will point out that Edison had another auction where there was, in fact, a significant amount of demand response and storage that was attained, not in the Moore Park one, but a different proceeding. So there is progress being made in this area. We are in the process of following up the once through cooling requirements in California, shutting down a lot of Eisen-era power plants, replacing them with newer, more efficient, fast ramping, so they're only running when they're needed, gas power plants. We are also we've built 7,000 megawatts of utility-scale solar in the state. We have 4,000 megawatts worth of rooftop solar in the state. It's not like it's all gas and gas only. So we are obviously concerned that the process basically recognizes the fact that within procurement, the utility they are looking to meet utility procurement plans. They don't do environmental siting, and I don't think you want the PUC, which is already stretched pretty thin, to be doing environmental siting. This is not a new issue. They've had that same policy since 1986. The issues with respect to cumulative impacts on EJ communities, whatever else, legitimate siting issue, and we have that within the California Energy Commission for power plants in excess of thermal power plants in excess of 50 megawatts. Power plants that are smaller are obviously taken care of under CEQA by other agencies. So we will take a look at the language here. Our big concern with the original language was adjacent to. We recognize, as I indicated, there may be impacted communities, but when you put the adjacent to issue on top of it, it expands it very, very broadly with respect to a broader group of people. Of the next 9 plants that are being proposed at the Energy Commission, 7 of them are basically along the coast. And the two others are basically, one is at an industrial park in Santa Paula. There's one in Blythe, and I think there's also one in Palmdale. So we do not believe there's a disproportional impact on there, and we do encourage a no vote. We will continue to work with Mr. Gomez on this to see if we can get to something that's a qualified yes. But thank you.
Thank you. Other witnesses in opposition? To the committee. Mr. Jones.
Thank you. Mr. Gomez, why only investor-owned utilities? What about municipal utility districts?
I'm going to let my experts handle the question.
We are, of course, also concerned about the municipal utility districts. This bill is intended to be a narrow fix for a process that goes forward at the Public Utilities Commission, which doesn't have authority over the munis.
How does this bill affect generation plants, the older generation plants that the utilities want to upgrade that are cleaner and more efficient than what's there now? Would they be able to do that, or would they not be able to do that?
So if it's a repower, they would be subject to this. Of course, this bill doesn't prohibit any gas-fired generation. It requires that the utility, when looking at long-term procurement, go through a process of trying to find first the cleanest resource and then the resource that has the fewest impacts.
Okay. Other questions, comments from the committee? This is, of course, the poster child used over and over again is in my district is and there are 3 natural gas power plants that were originally under the discussion, and one of them is in Oxnard. Oxnard is predominantly a low-income community, though the thing that struck me is that the other 2 are also one is sited in an even lower income community, and then the other one in Goleta is actually closer to thousands of low-income families in Isla Vista than the Oxnard one is. So when looking at these things, I felt it was important to really make for the PUC to make a really important move towards preferred resources if possible. I appreciate the author for taking the amendments, and the chair's recommendation is aye. Would you like to close?
Yeah, thank you, Mr. Chair. The legislative process, which it is a process, is meant to refine and develop bills as they move through. A lot of people are stuck recently on the idea that one committee can fix it all. I've never seen that happen, except appropriations once in a while. But even then, the work is finally tailored. So I appreciate the chair's willingness to work with me and some of the supporters of the bill. And all I'm trying to do is not prohibit any gas. I'm not trying to prohibit gas generation, energy generation. But what I'm trying to do is make sure people realize that communities are different, right? And they're different because of their history of environmental impacts and the different burdens. And we want to make sure that people take that into account when it comes to energy procurement. Not saying that it's automatically not going to be put into a disadvantaged communities, not saying it's going to be put into a non-disadvantaged community. It's just taking it into account. And hopefully we get to a little bit more of an equitable situation when it comes to the placement and the procurement of energy in the state. I ask for your aye vote, and thank you once again for being a joint author.
Please call the roll. Oh. Is there a motion? So moved. Second. Motion by Stone, second by McCarty. Please call the roll. It's due pass as amended and re-refer to appropriations.
Williams?
Aye.
Williams, aye. Jones?
Not moving.
Jones not voting. Garcia? Aye. Garcia, aye. Gomez?
Aye.
Gomez, aye. Hadley?
No.
Hadley, no. Harper?
No.
Harper, no. McCarty?
Aye.
McCarty, aye. Stone? Stone, aye. Wood?
It's 5-3. Your bill is out.
Thank you.
Mr. We're going to lift the call of absent members while Mr. Hadley sets up.
AB 716, calling the absent members Stone. Stone, aye. Wood. 1749, Gomez.
Aye.
Gomez, aye. Harper.
Aye.
Harper, aye. AB 1833, Gomez.
Aye.
Gomez, aye. Stone.
No.
Stone, no. Wood. 2002. Wood. AB 2029, Gomez.
2002.
2029.
By Dolly and Gordon.
Aye.
Gomez, aye. McCarty?
Aye.
McCarty, aye. Stone?
Aye.
Stone, aye. 2408, Gomez?
Aye.
Gomez, aye. Hadley?
Not voting.
Hadley not voting. Stone?
Aye.
Stone, aye. Wood? AB 2415, Gomez?
Aye.
Gomez, aye. Stone?
No.
Stone, no. Wood? AB 2534, Jones?
2534, not voting.
Jones not voting. Gomez?
Aye.
Gomez, aye. AB 2564, Gomez?
Aye.
Gomez, aye. Harper?
Aye.
Harper, aye. AB 2616, Gomez?
Aye.
Gomez, aye. McCarty?
Aye.
McCarty, aye. AB 2702, Gomez?
Aye.
Gomez, aye. Stone?
Aye.
Stone, aye. Wood? AB 2722, Gomez?
Aye.
Gomez, aye. Harper?
No.
Harper, no. McCarty?
Aye.
McCarty, aye. AB 2715, Gomez?
Aye.
Gomez, aye. Harper?
Not voting.
Harper not voting. AB 2781, Garcia?
Aye.
Garcia, aye. Gomez?
Aye.
Gomez, aye. Harper?
Aye.
Harper, aye. Stone?
Aye.
Stone, aye. Wood? AB 2800, Gomez?
Aye.
Gomez, aye. Harper?
No.
Harper, no. Consent bills. AB 2206, AB 2343, AB 2579, AB 2630, AB 2653, AB 2700, AB 2812, AB 2912. The motion do pass with the recommendation of consent and refer to appropriations. Gomez.
Aye.
Gomez, aye. Harper?
Aye.
Harper, aye. McCarty?
Aye.
McCarty, aye.
Please proceed.
Thank you, Mr. Chair. Ready? Mr. Chair and members, AB 2026 is a modest and reasonable bill to improve CEQA, to enable CEQA to continue as a robust tool to protect California's environmental quality while reducing some of the costs in both dollars and delay that some CEQA litigation has resulted in. As a member of this committee, I've had the opportunity to deliberate with you on many bills written to exempt certain types of projects from CEQA, from stadiums to water storage, from homeless shelters to road maintenance. I believe that our policy goal should be to improve CEQA so there is less need to consider exempting projects from its requirements. AB 2026 does not short-circuit or reduce the stringency of CEQA's provisions in any way. It simply requires that those who file litigation under CEQA identify themselves. As far as I know, CEQA is the only section of California law where lawsuits can be filed anonymously with the true filer unknown to the judge, the defending agency, or the public. This is not a theoretical concern. Today, 45% of CEQA lawsuits are filed anonymously. According to KPBS San Diego, as of May 2015, one lawyer and his law firm had sued on behalf of more than 30 so-called charitable nonprofits, almost all of which he and his family helped create, and all but 2 share the same mailing address as his law firm. This tactic is known as green mail. Members, our failure to improve CEQA has real-world consequences for most Californians. Just last July, our House passed yet another CEQA exemption. Included in a budget trailer bill, we chose to exempt water recycling, stormwater capture, and other drought-related water projects from CEQA. When our state is in its 4th year of drought and we need exemptions to get state water projects off the ground, you can see just how prevalent is the disconnect between the ideals of CEQA and how it is used in practice. Similarly, California has the most expensive housing in the country, and Los Angeles has the most expensive housing relative to incomes of any major metropolitan area in the country. Part of this is due to the appeal of California, but a significant part of it is also due to our failure to construct housing to meet the needs of our population. And I would emphasize that 80% of CEQA lawsuits target infill projects, the kind we generally want to encourage, versus exurban greenfield projects. Just a comment about real-world implementation of this. The language of this bill applies the standard in amicus briefs to help inform the court of how certain interest groups think the court should interpret laws. When these briefs are submitted, they are obviously done to persuade the court to look at an issue from that group's perspective. So anyone who contributes directly to the preparation of that brief is required to disclose themselves and their funding source. This bill would only apply to group members who are contributing directly to the CEQA lawsuit, not the entire membership. And I want to emphasize this. Environmental groups are not the problem. It is informally organized shadow organizations with no board members, no history, no filing requirements, and no disclosed funding stream. The committee analysis expresses the concern that this bill, AB 2026, is one-sided, that it requires disclosure from plaintiffs that it does not require from defendants. Mr. Chairman, as you know, I've expressed my willingness to work collaboratively with you on this issue. But in our review of the situation, it has not been defendants who have been hard to identify. The lead agency, the agency on the project, the one being sued, is virtually always known to the courts. And perhaps my first witness here can speak on this topic. I'd like to introduce Whit Manley from the Remy Moose Manley Law Firm.
Good afternoon, committee. Pleasure to be here. My name is Whit Manley, and I'm a CEQA litigator. I've been practicing CEQA for about 25 years, mainly on behalf of respondent agencies and real parties, but also on behalf of petitioner groups. And I support this bill. Standing to file a CEQA lawsuit is extraordinarily permissive. The bar is extremely low. And as a result, lawsuits are often brought by informal associations that form solely to bring CEQA litigation. The statute and the courts all allow this. Because these organizations are so loosely formed, it's often impossible to know who is behind a CEQA lawsuit. These permissive standing rules create an incentive, an opportunity to bring lawsuits for non-environmental reasons. If a petitioner need not disclose its interest, then a group can anonymously bring a lawsuit and thereby gain economic leverage or create a significant barrier to entry for a business competitor. And these are phenomena that I have seen and other CEQA litigators have seen repeatedly throughout our careers. This rule does not alter the rules regarding standing. It does not hinder people from bringing lawsuits at all. It does not target established environmental organizations at all. It is aimed solely at these anonymous, shadowy groups. There is a concern in the committee report that this applies only to petitioners, but as Assemblymember Hadley said, there is never any doubt about who the respondent agency is. There is never any doubt about who the applicant for a development project is. There is frequently doubt about who the petitioners are. There's a statement that this isn't needed because there are rules to dismiss frivolous lawsuits. Those rules are on the books. Those are about the merits. They're not about the identity of the petitioner. There is not a mechanism for finding out who is sponsoring CEQA litigation, and this simply provides that mechanism. I think daylight and transparency are a good thing. That is a nonpartisan issue to me. And I was heartened to hear those testifying in support of AB 2002 and in support of transparency at the Coastal Commission. This is no different. Transparency, if you're going to file a lawsuit, tell the court who you are. And I hope you'll support this bill. Thank you.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California and CJAC does support the measure. We note that a national law firm, Holland and Knight, did the most comprehensive CEQA litigation study that we're aware of. They looked at every single California case filed from 2010, 2011, and 2012. They found 13% of the cases were filed by recognized environmental groups, only 13% of them. They made 3 recommendations for improving CEQA litigation, and the first one is embodied by AB 2026, that is requiring disclosure of the identity of CEQA plaintiffs. I would note that the federal courts have always required identification under the National Environmental Quality Act. And in addition to the California Rules of Court as it relates to the identities of amicus curiae, friend of the court briefs, identification is also required for the recovery of attorneys' fees. From our understanding, the Judicial Council, who adopted those rules of court, have relied upon the legislature to determine whether or not this particular instance, i.e. identification of the plaintiffs at the time of filing, is a matter for the legislature to determine, and that's what you have before you in AB 2026. And CJAC believes that we should put an end to anonymous CEQA litigation and therefore supports the measure. Thank you.
Mr. Chairman, members, Richard Markison representing the Western Electrical Contractors Association, the Plumbing, Heating, Cooling Contractors of California, the Air Conditioning Trade Association, Associated Builders and Contractors of San Diego County, and the American Fire Sprinkler Association, all in favor of the bill. It's common sense, and we completely agree with the author and the previous witnesses. This makes sense for CEQA.
Other witnesses in support? Witnesses in opposition?
Good afternoon, Chair, members of the committee. Kyle Jones with Sierra Club, California. We are opposed to this bill. We think it creates an added burden to nonprofits that has the effect of preventing people from being able to sue to enforce the law on behalf of the public and for the benefit. I did also want to note that the Holland and Knight study that was reported, there are many problems with that study. First of all, the infill statistic used, that 80% of the suits target infill, is based on a definition of infill that includes any project within city limits or an unincorporated county adjacent to city limits, and doesn't actually focus on whether or not those are in urbanized areas. Some of these the cases cited involved a Walmart that was very close, in even a more rural area. So the other reforms that were identified in the report suggest that the problem is that only 13% of recognized environmental organizations are named in suits. But we don't think that there's anything wrong with an unrecognized environmental organization suing as well. Oftentimes you have groups that get formed because of projects, and by preventing those groups from forming and opposing projects, you're limiting the ability of these folks to really band together as community members in opposition. Additionally, it's not workable to try to figure out whether or not everybody is pure of heart when filing a CEQA suit. I think it'd be really hard if members of the local community were opposed to something to show that everybody didn't have a bias or some sort of commercial interest against the project. It just happens when you live in a community. Additionally, you then create some sort of a mini trial where you figure out whether or not someone's actually pure or not. And that just really increases the time it takes for these suits. With the amicus briefs, I would just note that the reason that amicus briefs have different rules is because to protect briefing rules and preventing litigants from actually getting around those by filing amicus as well. And so the motivations for that disclosure are wholly different than for filing under CEQA. We urge a no vote today. Thank you.
Mr. Chair, members, Cesar Diaz on behalf of the State Building and Construction Trades Council, strongly opposed to this legislation. Our justice system requires courts to resolve claims on their merits, unbiased by the popularity or unpopularity of the petitioner. The California Supreme Court firmly established that it's entirely proper for the petitioners challenging an agency's failure to comply with CEQA. They may have an economic impact as well as an environmental interest in the litigation that's being pushed forward. AB 2026 attempts to undermine the Supreme Court by focusing attention on those interests rather than on the merits of their claims, and strikes at the heart of our entire judicial system of law. It is designed solely for one thing. It is to taint the judicial process with bias against the actual petitioner. We believe this is a fundamental attack on free speech and freedom of association. It undermines community groups that may associate in their membership. It may impact their membership and their funding abilities by having this disclosure. And frankly, it's just the wrong thing to do with regards to what we've heard here about disclosure and about power plants and their siting. A lot of those actual groups were formed to look at where the siting of these power plants were. So this bill strikes at the heart of that, and we are strongly opposed. It's a wrong-headed move. It is not a CEQA reform. It's basically dismantling CEQA.
Other witnesses in opposition?
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in opposition.
Kelly Dunn on behalf of California Land Conservation Voters in opposition.
Victoria Rome with NRDC in opposition.
Other witnesses in opposition? Witnesses with testimony neither in support nor opposition? To the committee. Questions, comments? Mr. Harper.
In the first of the oppositional comments, it talked about the bill modifying who can bring standing forward. Does the bill do that?
No, Mr. Harper. This bill does not limit or prohibit in any way any party from filing a lawsuit. The witness for the Sierra Club that said that this would somehow prevent filing of these claims. That is not the case. If it is a group that's already been formed, that group itself can file a lawsuit without any additional information other than the name of that group. If it's an informally organized group of people, they are not prevented in any way. They just simply need to form an association or identify the members that comprise the group.
Mr. Chair, I think this is very common sense. I mean, to me, it doesn't make sense. I don't see the rationale in terms of keeping a secret of who is initiating this kind of litigation. I'll be supporting the bill.
I'll second.
There's a motion by Harper and a second by Jones. The chair's recommendation is no for some important reasons. While I don't quite agree that this would dismantle CEQA, I think that's a little of an overstatement. I do believe that it would have a freezing effect on those willing to file suits, especially, I come from a relatively small town, Santa Barbara, Carpinteria. When everyone knows everyone, not everyone likes to be in the limelight. Most normal people don't like being in the limelight. And when you are a contributor to a community group that is filing a CEQA lawsuit, you will be in the limelight. And so there is that question of, in my mind, a freezing effect over public participation. Our system is built on public participation, whether or not those people want to be in the limelight. I also find it problematic that the disclosure requirements would apply only to those participants in those organizations, not to individual plaintiffs or to defendants. And those disclosure requirements are sort of the economic interests, question. And so I find that to be asymmetrical. I guess at the end of the day, as annoying as it can be, I even support those who have chosen to cast themselves as my enemies' right to file a CEQA lawsuit without me being able to know who those are. So there are many local examples that I could point to, and if you have interest in the long run, I will. But the chair's recommendation is no. Any other comments or questions from the committee? Would you like to close?
Yes, thank you. Mr. Chair and members, it will never again, and it should never again, be fast and easy to engage in significant development projects in California. Our state is too densely populated. We value our environmental assets too greatly to just wave significant projects through with a cursory review. It is a false straw man argument to say that those who support CEQA reform want to run roughshod over our environmental considerations. But we need to be intellectually honest enough to acknowledge that CEQA litigation is too often used for purposes other than environmental stewardship, and that Californians are paying the price for the projects that never happen or that happen later and more expensively than they should. We pay those prices in the form of expensive housing, in the form of inordinately long commutes as exurban projects are irrationally favored at the expense of infill projects. We pay the prices in the form of uncertain water supplies and in many other ways. These ripple effects do truly hit many, if not most, Californians. Just to point out what a common sense bill this is, the protocol of this committee and every other committee that I sit on in this chamber, when we ask witnesses to testify or invite them forward, at the end we ask them for three things: their name, their affiliation, and their position. We aren't even giving the court in a CEQA lawsuit the information on one of the three things we ask for when we give somebody 15 seconds at the microphone. This is a modest reform. It does not limit the force of CEQA in any way. It only attempts to provide enough information and enough transparency to courts to determine, to help determine which suits are being pursued for purposes consistent with CEQA's purposes and which are not. And I respectfully ask for your aye vote. I'm ready to work with the committee to fine-tune the bill. But let's walk down the path of improving CEQA rather than to stay on the path that we are, where we grant CEQA exemptions for certain very urgent or politically connected interests. Thank you.
Chair's recommendation is no. Please call the roll.
The motion is due pass and re-refer to Judiciary Committee. Williams?
No.
Williams, no. Jones?
Aye.
Jones, aye. Garcia? Garcia, no. Gomez? Hadley?
Aye.
Hadley, aye. Harper?
Aye.
Harper, aye. Stone? No. Stone, no. Wood?
That's 3-3. We'll leave the roll open for absent members. Mr. Jones.